substantial effects doctrine, as a necessary and proper clause case, you realize that there is a limiting doctrine on the necessary and proper clause. In fact, there's a limiting doctrine on necessary in the necessary and proper clause, and that is the line that the Supreme Court drew in the case of Lopez versus United States, and then reaffirmed in the case of Morrison versus United States, and that is the line between economic and non-economic activity. What the court decided in the 1990s was that the substantial effects doctrine, which had been adopted by the court during the New Deal, had a limit. And that meant the word necessary in the necessary and proper clause had a doctrinal limit. And that limit was that Congress could not reach, under this theory, wholly intrastate activity that was non-economic in nature. Now, why draw the line at non-economic as opposed to economic? That goes back to what the meaning of the word necessary is about, and the debate that took place between Alexander Hamilton and James Madison about the scope of that clause with respect to the First National Bank. I'm not going to go into the details of that debate, but even Hamilton, who was the big government man at his time, basically argued that there was a limit with respect to necessary and proper. And what made something unnecessary and sufficiently beyond the Congress's power to enact is if it was remote. If it was a remote exercise of power, remote from the enumerated power. Now, we heard earlier this morning from Judge Wilkerson that you need judicially manageable criteria by which judges are going to constrain Congress's power. And I agree with that. I agreed with it earlier. I still agree with that. So what is it is not judicially manageable for the government, for the courts to assess the degree of remoteness of any particular aspect, exercise of power, as in an abstract manner. And in fact, that is really what the government is asking the courts to do in this case. They're saying, look, healthcare, it's unique. Examine this market, Judge. If you look at this market, you'll see it's different than any other market there is. So we want you to examine the merits of our argument, the merits of our policy, and on the basis of that, you are to make your constitutional judgment. I don't think that's what the courts will do, and I don't think that's what the courts should do. In fact, the economic, non-economic distinction is a way of getting at remote from non-remote exercises of the necessary and proper clause as it's conjoined with the Congress clause. The reason being is that when Congress seeks to regulate non-economic activity, well, let me start the other way. When Congress seeks to regulate wholly intrastate economic activity, that is very likely to be closely related and non-remote to its exercise of its interstate commerce power, as a means to exercising its interstate commerce power. However, when Congress goes over that doctrinal line and starts to regulate non-economic intrastate activity, that is likely to be remote from its exercise of its Commerce Clause power under the necessary and proper clause. So there you have a judicially administrable doctrine by which you limit the range of the word necessary in the necessary and proper clause. But now we face something new and unprecedented. And the new and unprecedented thing is when Congress seeks not to regulate any activity at all, but to mandate activity from a position of inactivity, or another way to say it is to regulate inactivity. So the question is there another limiting doctrine that the courts would and should adopt in order to limit the scope of the necessary and proper clause? And the answer is obvious. And that is, they should draw a line. Just as they drew a line in the past between economic and non-economic activity, they should, and I believe will now, draw a line between activity and inactivity, and do so for the very same reason. Because they don't want to get into the facts about particular laws and decide whether it is more or less necessary, which is what the government is urging it to do in this case. They want to draw a bright line that would separate the limited and enumerated powers of the federal government that were reaffirmed by Chief Justice Rehnquist in the Lopez case, and draw a line that is judicially administrable. This is that line. When Congress seeks to regulate wholly intrastate activity that is economic in nature, that is likely to not be remote, that is likely to be close or incidental to the exercise of its Commerce Clause power. Similarly, with the new theory that the government is arguing for, which is based on dicta in Lopez, dicta in Raich, and also Justice Scalia's concurring opinion in Raich, that Congress can reach even wholly intrastate non-economic activity if doing so is essential to a broader regulatory scheme. That's the new theory, and I believe it's predictable that the courts will adopt that theory. The economic and non-economic distinction line provides the limiting doctrine of that doctrine as well, of that theory as well. Okay, Congress can reach wholly intrastate activity that's non-economic in nature when doing so is essential to a broader regulatory scheme, but it cannot reach wholly intrastate inactivity. That is a line beyond which it will not go. So let me just close. I see I've got to close now. Let me just close by saying this. When you get up in oral argument and you argue a case like this, the most telling arguments against you are the slippery slope arguments. If we rule for your counsel, we're going to have to rule what other laws are we going to have to undo? What other laws are we going to have to strike down? In fact, those were some of the toughest questions I had the day that I argued Gonzalez versus Raich in the Supreme Court of the United States. But whenever the lawyer gets up to argue this case, they're going to have, and they argue this principle, this limiting principle, the inactivity line with respect to Congress's Congress clause power, they're going to have a very easy time of it. Because as it turns out, there would only be one law that would have to be struck down as a result of adopting this particular doctrine. It is the individual mandate. And you know why? Because it's unprecedented. Because it's never been done in the history of this country. And no other law would be affected by adopting this limiting principle, making it that much easier for a court to adopt. Thanks.